The United States and many other countries have a long history of adopting Native children out of their communities, placing them with generally white families, who end up erasing much of their culture and much of the roots of where the child came from. Now, this was combated specifically with the Indian Child Welfare Act of 1978. At that time, 25 to 35% of Native children had been taken from reservations and placed into the care of white foster families. This on top of residential schools and the whole horrid history behind that. But right now, that protection may be overturned because of a single adoption lawsuit. The Bracking family did foster care for a Native child and later decided to adopt him. With the ICWA, Native family members had priority for custody of the child. Thus, their adoption claim was denied on that basis. They fought on for the adoption, and a Texas court violated the ICWA, giving them custody. Now, despite the fact that they actually won the case in violation of the ICWA, they're escalating the entire situation to the Supreme Court in order to try to change the laws. All of this, they say, is to protect children. The foster father, Chad Bracking, said,
"Not all cases end the ways ours did. In fact, we hear stories of other people in the same situations across the country. Like there's 2 other families in the state that are going through the same pains and struggles that we are and fear for their children. We did that so that we can advocate that their best interest, the interest of the child, is what is considered in these adoptive placements, not their race."
The family claims that the ICWA is violating their constitutional right, which is really ironic given the history of people like them stealing Native children away and erasing their Native identity. What we have here is laws very similar to affirmative action. To oppose this law in trying to keep Native children within Native communities is like trying to overturn affirmative action because you feel it is unfair to you as a white person, thus violating your constitutional rights. The problem with their argument is that the ICWA doesn't operate under race. It acts as a part of treaties, a political category under the law. The ICWA only applies to children who are members of a federally recognized tribe or eligible for enrollment. This would not apply to a child who is Native but not a member of a tribe. The ICWA does not operate on the basis of race. It operates on the basis of a legal agreement between Native tribes and the United States government. Now, this very fact is what is trying to be overthrown here. And what we have is a very sinister plot by big business. The lawyer for the family, Matthew McGill, works for the law firm Gibson Dunn. It has a long history of attacking Native rights in courts. They've also worked for Amazon, Chevron, and Walmart, and most importantly, the Dakota Access Pipeline. In the past, the law firm has represented the gaming industry in a suit to break up Native monopoly on gambling using the same race-based arguments. Now we get a better idea of what's going on here. We see what's really going on. They are claiming a violation of the 14th Amendment, which says the law cannot treat people differently based on their race. The problem here is that this law is not based on race. It's based on a treaty, a contractual legal obligation the United States government has with Native tribes, which is 2 completely different things. Now, the implications of this are very clear. This same argument that the law is supposedly racist was used to try to break up a monopoly that's owned by Native communities. And in some states where gambling may be illegal, is still legal on casino on Native land, tribal land, They made the argument that it's racist, that they're only allowed to go because of what race they are. They're allowed to have casinos because of their race, which is not the basis of the difference. It's the contractual obligations between the United States government and the tribe. But you see how they're claiming this is racist by invoking the 14th Amendment. Now this, applied to many other things, is going to open the door for a lot of other things. For example, much of the oil industry is hindered somewhat by the rights of Native people to their land, i.e. the Dakota Access Pipeline, which eventually, had tremendous legal difficulties because of those treaties, which they attempted to fight in court. You could overturn all kinds of protections for indigenous communities if you can rule that the treaties are racist, even though the basis of them is not race, but a contractual obligation with a tribe. But you can see what they're aiming at here is to be able to give a freer hand to big business to go into areas where they are, one, usually not even wanted, and two, to violate the sovereignty of many indigenous people. Now, Title 25 of the U.S. Code guarantees certain health protections, like health services, to indigenous people, even if they're not on a reservation. That could then be sued for by someone on Medicare and Medicaid to essentially stop those healthcare, or to force them to receive the same treatment or medical options, because the precedent had already been set that the protections, the kind of like affirmative action, was racist. And I think we know which direction that would go in. I think the pharmaceutical companies, the insurance industries, etc., would lobby the hell out of it to make sure that as very little protection for Native people would exist. That way they'd be forced to get private insurance, and the private insurance companies would make money. So what we see here is essentially one family arguing that because God told them to adopt a child, wants to overturn the entire history of protections and the treaties between the United States government and Native peoples simply for their own religious delusion of a responsibility to adopt a child, which would essentially open the door to all kinds of injustice against Native peoples, which apparently doesn't mean anything to them whatsoever. This is all about them getting their native child that they wanted from the beginning. And we also see here the very pernicious nature of capital. Capitalism, if anything, has spent centuries undermining human rights in any way, shape, or form, specifically for the purpose of making money, and then declare capitalism to be freedom, democracy, and human rights, when it is very clearly the opposite. Thank you for watching. If you like this program, then please head over to my Patreon page and set up a monthly donation. It's your donations that keep this program running. Also, if you would like, please rate, comment, subscribe, and share in various social media.